Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for argument in Phoenix Newspapers, Inc. et al. Versus the Honorable Aaron Otis, respondent in the state of Arizona, and John Michael Allen, real party in interest. Our special action number 17-0286. Each side will have 20 minutes within which to present their arguments here this morning. The appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of the time in that regard. We have gone through the record. We've read the memoranda or briefs submitted by the parties. We've conferenced the case. So we're fairly familiar with the underlying facts, although we may have some questions about what happened and when as we go along. We're recording the proceedings, both by audio and video, and the video will be available within a matter of days on YouTube. So if you're really interested, you can check there. But as you approach the podium, please identify yourself and your client or clients for us. With that, Mr. Bodney, you may proceed.
Good morning, Your Honors. My name is David Bodney. I'm here on behalf of the petitioners, Phoenix Newspapers, Inc., KPNX Broadcasting Company, Meredith Corporation, and the Associated Press. With me at council table is Chase Bales. We are here for the petitioners, and I hope to reserve about 5 minutes, and I'll keep track of my time. May it please the court. This special action concerns a trial court order that violates petitioners' constitutional rights in 3 fundamental ways. First, it operates as a classic prior restraint, what the United States Supreme Court and Nebraska Press Association called the most serious and least tolerable of infringement upon First Amendment rights. Number 1, this is an unconstitutional prior restraint that freezes petitioners' rights of speech. Number 2, it also violates the First Amendment because it imposes a restriction on the ability of the petitioners to speak and publish information that was disclosed in court records and proceedings. This triggers a second First Amendment basis that starts with the Cox versus Cohen case in 1975 involving an attempted prohibition on the naming of a murder-rape victim, extends through the Nebraska Press Association case into the Oklahoma publishing case in 1977, Smith versus Daily Mail in 1979, and summarized by the U.S. Supreme Court in BJF versus Florida Star in 1989. Number 2, this prohibition chills freedom of speech. And third, the order violates the Arizona Constitution, Article 2, Section 6, by limiting petitioners' right to, and I quote, inform the public of that which had transpired in the course of a judicial hearing, close quote. Those are the words of the Arizona Supreme Court more than 50 years ago, announced a decade before the U.S. Supreme Court came essentially to the same conclusion in the Nebraska Press Association case, followed by the Oklahoma publishing case. So if we look at the classic prior restraint first, the analysis was formulated by Judge Learned Hand in United States versus Dennis. And the court adopted that in the Nebraska Press Association case, asking essentially, what is the gravity of the harm discounted by its improbability? And Justice Berger, writing for the Court Nebraska Press Association, identified a 3-part test. What's the gravity of the harm? Number 1. Number 2, did the court consider less drastic alternatives? And number 3, what's the efficacy of the order? How effective might that order really be? And so if we look at each of those elements, and the court said there must be findings to support a prior restraint, because a prior restraint comes to the court with the heaviest of presumptions against its unconstitutionality. It involves the most compelling circumstances. So
I guess the argument that the prosecution is making here is that it's obviously an unusual situation.
Pardon me.
And in terms of the gravity of the harm, you had the jurors presumably at home, the jurors in the stalking case, presumably at home or at work, not in the courtroom, not in their jury room or in their courtroom, so that they were online momentarily. How do you respond to that in terms of the urgency of some need being met?
Judge Johnson, I would respond to it by analyzing the case through each prong of the three-part test, and there's no basis for this order. The first is, what's the gravity of the evil? It is speculation upon guesswork, upon conjecture, that a jury that has already been instructed in one case would learn the identity of a prosecutor in another case, put 2 and 2 together, and discover that that prosecutor prosecutes capital crimes, and therefore the juror would somehow be incapable of discharging the duty to be untainted and follow the court's instructions in that second case. So it involves a level of speculation that the Supreme Court has said is intolerable in a prior restraint case like this. The second point I would make, Your Honor, goes to...
Before you move on to the second point, do we know what instruction the jury in the stalking case received in terms of media exposure?
Judge Cruz, I don't know. I wasn't there. I've seen the court records in that case where the alleged victim is identified by name in that case, identified as an employee of the Maricopa County Attorney's Office. We also have these 2 trials going on effectively simultaneously in October and November. And so when we do get to the second test, the least drastic alternative...
Just to follow up on that question, Mr. Bodney, in your review of the record from the stalking case, did you see the preliminary instructions to the jury or any instructions to the jury concerning the media?
Judge Winthrop, I did not see particular media-related instructions, but this is where the less drastic alternative comes in. And again, no less a court than the United States Supreme Court in Nebraska Press Association said, here are the things a trial judge should consider doing before imposing a prior restraint. 1, clear and emphatic instructions to the jury. So if the judge in the stalking case was concerned about media coverage, which had been taking place in the Allen case weeks before, days before, certainly, where the prosecutor was named and appeared in a capital case, she is the chief capital litigation bureau, chief of the Capital Litigation Bureau. All that was known in both cases. So emphatic and clear instructions, number 1. Number 2, searching questions of jurors. Presumably, there were communications going on between these 2 judges. We don't know. That's part of the problem. There's no record. We know from the record we could find and get transcribed, pay for and produce, that it had come to the respondent judge's attention that these jurors were going into deliberations. The judge in that case could have issued searching questions of the jurors. In addition, two more things that could be done. Judge Johnson, back to your point. The court said, better to consider postponing the trial. The respondent judge here thought it would only be a day, maybe 2 days. We don't know for sure how long a jury will take to deliberate and decide aggravating circumstances. Better to postpone. And the court also identified sequestration of the jury. So, in answer to the question, it would seem to me that if there was a genuine, as opposed to speculative, concern about the impact on jurors, the judge could have contacted the jurors and reminded them, if no instructions had been made ab initio, don't read the news about this case or any other cases until you're finished with deliberations. Don't watch television news about this case or other cases.
Wouldn't that have been a little problematic here, though, Mr. Bodney, that the jury we're talking about is the stalking jury, which presumably is at home. They're in a recess period before. That's my understanding from the record. And so I'm trying to understand the analytical, the theoretical construct of the appellate court's directions to the trial court and apply it in a real-life situation where you have a very difficult case, this murder case, in front of a jury that's trying to proceed to conclusion. And you're suggesting that the trial judge there should have recessed that matter and either held an evidentiary hearing or reached out to Judge Fink, the judge in the other case, to try and have some meaningful interaction with jurors who weren't in the courthouse. I'm trying to understand that. Is there some sort of balancing that has to go on here?
Judge Winthrop, I think that is the three-part test. And there's no evidence of where these jurors were or whether they could or could not be reached. Presumably, they could have been reached if that had been a real worry. But that then takes us to prong 3 of the three-part test, by which we know for a certainty that the identity of Jeanette Gallagher as the chief of the Capital Litigation Bureau is a known fact. Her name, her position, her role in a capital case, the Allen case, was a matter of public record before the issue on November 6 even came to light. And her name and position with Maricopa County was known in the Heitzman case before this issue came to light. So Judge Hand says, and the Nebraska Press Association case says, and our Supreme Court said in KPNX, we have to ask how effective the order would be. And it would be entirely ineffective because anybody wanting to put 2 + 2 together had weeks, if not months, to do so. And the notion that an injunction on speech and press of the identity of the lead prosecutor would somehow solve a problem that has not been shown to exist, is compatible with the First Amendment, is inconceivable.
So you still have plenty of time, but I want to make sure I understand something here. I think it's clear you believe that there's an impermissible prior restraint here, and you want us to say that. What else are the petitioners looking for in any sort of written order from this court?
Your Honor, as I think about this case, I think about 2 very powerful forces in society, the alignment of 2 very powerful interests. One is the state, which can put persons to death in this jurisdiction. Another is the prosecutor, who argues for that result for the state. Another powerful force here is the judiciary. It's the judge responsible for balancing a number of interests. What got lost in the shuffle in this case is well-established rights of the press and public to speak. And if a judge has the power to enjoin for a period of days, here it was effectively at least a week, The identity of the lead prosecutor in a capital case, where does that end if this court doesn't send a signal about the importance of our constitutional rights, not as mere punctilios, but as fundamental bulwarks of our liberty? That's something that needs to be said and said again, certainly today as ever before. And so it seems to me that procedures are important. I struggle with the procedures. What should the judge have done? What should judges do in this situation? We were rushed out of the hearing. We were an inconvenience. No one wanted to hear from the press or the public. The judge wouldn't allow for a week's time a camera into the courtroom. So when a judge gets information from some undisclosed source that there is a risk to fair trial rights, or perhaps the prosecutor's rights as a victim in another case, it's terribly important that the judge issue findings. We didn't have findings. We had a suggestion editorially that, well, you don't have to cover Ms. Gallagher, her name spoken in public proceedings. Cover Mr. Rademacher. He's here too. Write about him all you want. Those aren't findings that the Constitution requires. Some effort to comply with those standards is terribly important. And when courts disregard the standards, when they say that we can enjoin the publication of speech about a public official when she's exercising her public duties on a topic no less important than life and death, where does that end? Where does the judge have the power not to say these things about other public officials in other cases where it maybe is something more than the prosecutor's name? Maybe the indefinite period of time is more than a couple of days or a week, but in an age of terror and insecurity, a trial court judge says, that's okay, thou shalt not speak. And by the way, how I got my information and the standards I used to get there are a very little moment to this court. Thank you very much.
Is there any relief that would be appropriate for this court to grant now?
Your Honor, I think it's terribly important to recognize that this is a case like KPNX, like Nebraska, like Oklahoma, and on, capable of repetition yet evading review. Criminal trials typically are of relatively short duration. The state's response to our papers in this one indicates that they think the right result happened here, where justice was served. I forget the exact expression, something along those lines. It served its purpose. The order served its purpose. I would ask, what was that purpose? Was it to get convictions for Ms. Gallagher in both cases? Or was it something closer to justice? So a recognition that this is capable of repetition yet evading review, if not of statewide public importance, and clear instructions to a trial court that this isn't how we do justice in Arizona.
In your brief, counsel, you point out the fact that the trial court never issued an order that altered the scope of its prior ruling, but the court, the order by its own terms was to expire after the stalking trial was ending. So you're no longer holding on to that position that some order should issue lifting that ban? Or
Judge Cruz, that's a very good point, a very good question, because we really were left in the dark. Not only were there no findings, no meaningful hearing, but we had to struggle to find out what the judge meant by the order and when it truly expired. We didn't know if it ended when the jury came in on November 7 with its finding of guilt, whether it ended on November 8, ultimately, when it found aggravating circumstances. On November 9, if I have my dates correct, we filed our request for clarification and reconsideration. It wasn't until a week later on a Monday when we hear from the judge's or the court's public information officer that we're now free to use the prosecutor's name.
Of course, Mr. Bodney, you could have submitted a proposed form of order following that in-chambers hearing, which laid out your understanding of the parameters of the order and its anticipated duration, but you chose not to.
Yes, Your Honor, we could have. We thought the request would have been more effective ultimately, but we could have submitted a proposed form. I see I'm perilously close to being entirely out of time, so if I may,
Thank you.
I'll rest. Thank you.
Mr. Grant?
Good morning, Your Honors. May it please the Court, my name is Jerry Grant. I'm a Deputy County Attorney representing the real party in interest, one of the real party in interest, the state of Arizona in this case. Before I get into the main part of my argument, I did want to respond to one thing that counsel said. He indicated that Judge Otis, had not allowed cameras in the courtroom for a week. That's not quite true. The record clearly shows that a media request was made at the beginning of this trial, and Judge Otis set a hearing for it, and no one showed up. Because no one showed up, she decided that request was abandoned. That's why there was no media coverage up until nearly the last day of this trial, which is when the request came in.
And that's a
what she dealt with.
procedure that's laid out by the Supreme Court in its rules concerning this.
Correct. She followed the procedure.
I'm sorry. We know that the jury was about to get the case in the stalking trial.
They had the case in the stalking
They
trial.
had the case, but they weren't
They had-
deliberating that day.
Correct. They were in recess.
Okay. And where were we in the parallel trial?
In this trial, the capital trial, it was, from what I can tell from the record, it was the last day that evidence was going to be presented.
Okay.
That's when she considered the request.
Okay.
And I believe deliberations started the following day. I may be wrong on that.
Okay. And we got the transcript of the hour or so in which Judge Otis issued her oral order. Do we have any other understanding about how that order came to be? Did the state request it?
The state did not request it. The court asked, after she announced what she wanted to do, the court asked both Mr. Allen's attorney and the state's attorney if they had any objections. Neither of them said anything. And it was brought up by the judge. It was not brought up by the state.
Okay. And okay.
Is it the state's position that there was no other way in which the interest of both defendants, the defendant in the stalking case and in the death penalty case, and the victim, that is the prosecutor at issue, the interest of all the parties could have been assured? Is it the state's position that this was the only way?
Essentially, yes. That's not my main position, however.
Well, so what was the stalking case jury instructed? How were they instructed with regards to media and their exposure?
We don't know that. It's not in the record. I would presume, presumptions can be wrong, I presume they would get the standard instructions regarding media exposure.
And often are they not instructed that they are not to talk about the case, about the parties, about the court, about the lawyers?
Right. That's a standard instruction.
And another standard instruction is that they're supposed to make their decision based on the evidence, not on
Correct.
anything else.
Correct.
Is it correct that as far as the record reveals, the judge in the stalking case limited the description of Ms. Gallagher in court to merely saying she was an employee of the county attorney's office? And so there was understanding there she was not to be identified as a prosecutor.
From what Judge Otis says on the record, it's employee. I'm not sure if it went as far as prosecutor. Judge Otis did say that it limited the stalking jury from knowing that she was a capital litigator.
They could not know that.
Correct.
Okay.
The judge in the stalking case precluded the jury from knowing that she was a capital litigator and that she was the bureau chief of the capital litigation section of the Maricopa County Attorney's Office.
Okay.
Those are the two things we know from the record.
And she had been the prosecutor in the death penalty case for how long already when this order came up?
I believe the trial had gone on for under 2 weeks. It was a fairly quick trial from that all is not in the record. That's just from my own personal knowledge.
You're speaking of the Allen case now.
Correct, the capital case.
Yeah.
Okay, and in the same courthouse?
Correct. Yes,
They weren't on the
I
same
believe
hallway,
so.
were they?
Yeah.
There
That's
was-
not in the record, but I would certainly think it was in the same courthouse.
Okay, so the trial in the death penalty case had been going on for some time, and on the last day of presenting evidence, this issue comes up whereby the media is precluded from mentioning the name of the prosecutor, which has been spoken all along in the case.
Correct.
And so it's your position that there was no way to preserve her interest as a victim other than to shield the public from knowing her name on the last day of
Well,
evidence?
A couple of things in response. I don't believe the primary purpose of Judge Otis's order was to protect Ms. Gallagher. I believe the primary purpose of Judge Otis's order was to make sure that the order that Judge Fink had entered in the stalking trial was not violated by the coverage revealing media coverage, television coverage, which is what we're talking about here, is a little different than print. And especially in a situation where the jury in the other case, the stalking case, had started deliberations, but were on apparently a 1-week recess. Were not scheduled to return to their deliberations until the day after this issue arose.
But we don't know exactly what Judge Fink's order said.
Other than you cannot, well, you mean the order regarding,
The media.
The order to the jury in the stalking case, we don't know exactly what that order was to that other jury.
there was an order that they were not to know certain things about Ms. Gallagher, but we don't know what the general jury instructions were in that case.
All right, in terms of their exposure to media and so forth.
Correct.
So then, doesn't the fact that we don't have all of that information affect what position we should take on whether or not this is the only way to ensure due process for all?
Well, my main position, which I haven't gotten to yet, is that there's no need for this court to get involved in that at all. The issue is moot. We're dealing with an order that expired almost a month ago, and contrary to what counsel was arguing, the terms of the order were very clear, and I think I have them.
But isn't this an issue that's certainly capable of repetition? Not necessarily the fact where you have a prosecutor who's also simultaneously a victim in another case, but an issue with regards to a judge ordering that the media not disclose certain information.
Certainly, general media restrictions like that are capable of repetition, but I think you need to consider the extremely unique facts here that produce the order that's at issue. We have a capital trial ongoing, with the prosecutor in that case having recently just testified as the victim in another case. You have a jury in that other case that's deliberating and in recess, and presumably at home. Some of them may have been out of town even because they were not scheduled to return until the day after this order was issued. You have the issue of television coverage, which is fairly prevalent. People watch the news, and it may be inadvertent that jury may have come across a picture of Ms. Gallagher seeing in this capital case, and they may have learned something that they were precluded from knowing in that case.
Did the court allow, I'm trying to remember, did the court allow a camera on that day? I don't think the court did.
No, I believe the court did, but prevented them from showing Ms. Gallagher, which petitioner not contesting.
Oh, yeah.
So there was a camera present, yes.
So you mentioned a few minutes ago that the TV issue made this more of a concern. How is that so?
I think the risk is greater. The television coverage is more prevalent. Even though jurors are instructed to avoid that sort of media coverage, it can always happen. And particularly in a case where a jury is at recess for an extended period of time and is not able to be at that moment that this issue was being raised, assembled and instructed.
So while a juror would refrain from reading an article in a newspaper, the juror might not be so conscious of the need to restrain from seeing something on TV. Is that the issue?
Well, I don't think the jurors are normally instructed to avoid all media coverage. I think they're instructed to avoid information regarding that particular case. A juror could certainly be watching the news for any other purpose.
Doesn't that happen sometimes, though, that the courts do order jurors not to avoid media coverage, not to be exposed at all?
Of that particular case.
No, in general, for a period of time, to avoid media coverage. Does that happen sometimes?
I'm not sure. I'm not sure I can answer that question definitively.
So doesn't that take us back to the issue of, shouldn't there have been some inquiry to find out exactly what it is that they've been ordered to do and not to do, so that then we can make decisions in this case as to what's necessary?
That may have been something the court could have done. But again, the judge is operating in the middle of an ongoing capital trial. She's operating with another jury that's in deliberations and out of the court's reach, a jury that she isn't the judge in that trial for, and a media request that could well result in that other jury learning things that that judge felt was the judge in the stalking case was significant enough that they should know. And again, this order was limited temporally. The judge clearly stated that if that jury comes back tomorrow in the stalking case, you can do whatever you want. That's what she said. And counsel's statement that it lasted for a week is simply not correct. It expired by its own terms once that jury in the stalking case had returned its verdict, which was 2 days after the order was made.
Well, I guess one my questions would be, no doubt life and death cases are serious, the most serious the courts can hear, but aren't First Amendment issues serious as well?
Sure.
And the right of the people to be informed of what happens in the courtroom, and when there's some questions about what's the best procedure to follow, wouldn't it be incumbent upon all parties to stop even a death penalty trial and hold a hearing and make decisions based on solid information?
Certainly, the press has a right under the First Amendment. We also have a right under the Sixth Amendment for defendants to have a fair trial. We also have a right for victims to have a prompt and speedy resolution of that case. So the judge here was balancing three different rights. The cases none of the cases say that the First Amendment right trumps every other right. There has to be a balancing. And getting back to my mootness argument as to whether this is capable of repetition, I'm not a student of probabilities, but for all the individual unique factors that occurred here that resulted in a limited temporal ruling to reoccur, I think the prospects are slim, not even slim, but none. I don't think you're ever going to find a case where a judge is dealing with a media request in a highly publicized capital trial, where the prosecutor in that highly publicized capital trial has also testified as a victim in an ongoing other trial, and where the judge in that other trial has restricted that jury from hearing certain things. I think because of all those unique factors, this is something that's not capable of repetition. And if you look at some of the cases that discuss that deal with orders that have expired and have found that they are capable of repetition, they're nothing like this case. Most of them are pretrial orders by judges in generally high-profile cases, restricting media coverage in an attempt to preserve a fair trial right for the defendant. This wasn't pretrial. This is in the middle of an ongoing trial, and it doesn't even involve just one case. It involves two juries and two ongoing trials. I think that those particular unique facts are what make this issue incapable of repetition, and there's no need for this court to get involved in it and deal with all the other First Amendment issues. Unless the court has other questions.
Thank you, counsel.
Thank you very much.
Honors, if I may, in the time remaining, clarify a point. I appeared in the Allen case on the morning of November 6 in connection with a routine camera request, which had been made a week earlier and was set for hearing on the 6th. It was after and that request was by the Arizona Republic, Phoenix newspapers. Meredith Corporation had made a camera request for a video camera. Evidently, there was a hearing. I don't know what kind of notice of that hearing was given. I didn't get it. No one showed. That request was denied. So when I appear in court on behalf of Phoenix newspapers, I'm hearing the judge say, I will grant, finally, the Republic's request for one still camera conditionally. And the first condition I heard didn't especially trouble me under Rule 122 because it imposed a limitation on showing Ms. Gallagher. I may not think that's fair. I may not think it's editorially correct, but we were prepared to live with that. It's when she went on and said things like, I just don't want her name in print or her image on the news until that trial where she is a victim comes to completion. You see our dilemma. It's broader than just, I don't want her name in print. It actually says, or her image in the news. And on page 6 of the transcript, there's a similar confounding reference.
So the order barred you from grabbing a photo of her from somewhere else and putting it and broadcasting it or printing it.
Potentially, Judge Johnson, and that's why we sought clarification of the order. I see I'm out of time. I have a number of points I would be happy to respond to, but I don't mean to overstay our welcome.
Thank you, Mr. Wagner. We appreciate the arguments of counsel here this morning, as well as the written submissions. We'll be taking this matter under advisement. We'll issue a written decision in due course. We're going to take a short recess to allow counsel for the next argument to come forward and get set up. Thank you.